Hi, this is Ed Sullivan and Mark Oberti with Oberti Sullivan LLP. Mark is a board certified labor and employment lawyer, as am I, but Mark spends a lot of his time on non-compete cases. And the question here, Mark, is it's not unusual for employers to draft up very broad non-compete agreements. They scare a lot of employees. But what happens if that non-compete agreement is too broad? Does that employee have any rights or options, or does that mean the whole thing's invalid? What does it mean?
Yeah, there's different types of approaches to this. Some states are called blue pencil states, others are not. A blue pencil means the court will have the authority to say, okay, employer, this agreement is too broad, it's beyond what's really necessary, but I'm going to, as a judge, I'm going to reform it. I'm going to blue pencil it. It's called reform it to where it's more narrow. For example, in Texas, generally speaking, for a run-of-the-mill salesperson, the employer can bar them from dealing or soliciting customers that they had personal dealings with at their company, but not just the company's entire customer base, okay? So oftentimes you'll see non-competes that say, well, you can't solicit any of our customers, not just the customers you had dealings with. And under Texas law, for the most part, there's some exceptions, that's considered overbroad, but that doesn't shoot down the whole non-compete agreement. The court will just blue pencil that and then enforce it as to the employees, as to the customers that the employee personally dealt with. So it doesn't get you out of it entirely just because it's overbroad. The one thing you might ask yourself, well, why wouldn't an employer then always make a non-compete agreement overbroad? Well, the legislature thought of that, and in the statute in Texas, it says, well, if it is overbroad, even though the court can blue pencil it and reform it so that it will be enforceable, any damages that are incurred as a result of the breach of the non-compete up until the time the court reforms it or blue pencils it, the former employer cannot recover. So that's the incentive for trying to make it reasonable and not overbroad in the first place.